Today we are going to be looking at the operation of the prior use exemption in section 119 of the Patents Act. We will be looking at what a patent infringement is, what the prior use exemption is, when the exception will apply, and we'll test your knowledge at the end. Under Australian patent law, a patent gives a person the exclusive right to exclude others from making, selling, or using a product, process, or method that they have already created or invented. A person's invention or creation is protected by the patent for a specified period of time. If another person makes, hires, sells, uses, imports, or otherwise disposes of an invention or creation that has been patented by an inventor, or asks another person to do so without the permission of the inventor, the person infringes the patent. An infringement of a patent can result in the inventor suing the infringer for damages or compensation. However, there is an exemption to the patent infringement called the prior use exemption under section 119 of the Patents Act. The prior use exemption allows people to do what they were doing or had taken definite steps towards doing immediately before a patent's priority date. Generally, the priority date is the filing date of the first patent application that is linked to the patent itself. The exemption is available to persons who have made public use of the invention before the priority date, and it also extends to prior users whose activities have not made the invention available to the public. However, the exemption will not apply if the person infringing the patent took the subject matter or the idea of the invention from the patent inventor without their permission. The prior use exemption will also not apply if the person had, before the priority date, stopped making the product or using the process other than temporarily, or had abandoned the steps previously taken to make the patented product or use the process. So let's consolidate what we have learned about the prior use exemption so far. John was inventing a new type of name tag during 2016. It was like no other name tag that had ever been invented before. The name tag was patentable as it was in the manner of manufacture. It was novel, it involved an innovative step, it was useful and was not secretly used before priority date. On 10 June 2017, John applied for a patent to protect the new name tag he had invented. On 10 July 2017, the patent was registered. However, Jen was also making a name tag identical to John's in 2015. Jen had never met John, nor did she know about the name tag he had invented. Jen's name tag was not subject to a patent. John found out that Jen had been designing the same name tag as him and thought she had copied the patented version of the name tag. Therefore, John brought an infringement action against Jen for making the name tag that he had patented without his permission. On face value, Jen has infringed the patent by making a product covered by John's patent without John's permission. However, under the prior use exemption, as Jen was making the name tag immediately prior to the priority date, which was 10 June 2017, when the patent application was first filed by John, Jen may continue to make the name tag without infringing the patent, even though the patent has now been granted to John. The prior use exemption operates to defeat an infringement, as Jen had already started to make the name tag before John had filed the application for the patent. I hope this video has helped explain the operation of the prior use exemption in section 119 of the Patents Act.